All right, let's go ahead, sir. We'll take the state's motion for order and limine first. State,
You have the first request that looks like the state or the defense is contesting is the state's request that the defendant be prohibited from making reference to contents.
I'm gonna need you to speak up much louder than that.
Sorry.
Okay, Go ahead.
That the defendant should be prohibited from making reference to the contents of any document such as a police report that has not been admitted into evidence except for impeachment purposes in a manner in accordance with the rules of evidence, including omissions.
you can use negative impeachment.
And that's all I'm saying. And we only plan on using it when it attaches to a material point, a part in the investigation. We don't care about what color the sky was.
Yeah,
Not
you can use it for negative impeachment, but it will be granted without prejudice. I know you're asking me to grant in part, deny in part. I'm not going to do that. It's granted without prejudice. You can use for negative impeachment. All right, next. Number 2, go
2
ahead.
through 5, we did, defense has no, we are asking the court to agree with the statement. Yes.
All right. So the court is going to grant as to 2 through 5. Number 6.
State's requesting to call any of its believed to call any of its listed witnesses as rebuttal witnesses if necessary.
Well, depends on what the defense does in terms of you calling rebuttal witnesses, right?
Right.
So
I just asked, it's within the court's discretion based on the.
I'm going to grant it without prejudice. Next,
We are stipulating and ask the court to grant, I mean, we've already argued the motions, any motions to suppress. I don't think there is one.
all right, grant as to paragraph 7. Go ahead. 8.
The state is seeking to exclude any statement made by the defendant if offered by the defendant. The defense has argued that his prior statements would be admissible as impeachment should a state witness testify with statements that are demonstrably contrary to what he was said what was said by the defendant during interrogation on the police station body-worn camera. And that's fine. We can agree on that.
Right, there's only, it's a portion around before and after Miranda where him and the officer are discussing, and officer testifies to something that is completely different than what's on that footage, that in order to use that.
All right, so Mr. Sinatus is arrested. He's taken to the police station. What happens?
He's placed in a holding cell. The lead officer reads him Miranda and asks him some questions about what happened.
Okay, and that's all video recorded?
Yes,
Okay, is that going to be played for the jury?
yes.
Okay,
And we have no objection to that being played for the jury. The state, I don't know if we discussed it before. You have no objection to that interaction.
well, it wasn't the subject of any kind of suppression motion, right? It was a post-Miranda
No, it's correct.
statement.
I believe it was things were done correctly in that sense.
All right, so that will be granted without prejudice. Number 9,
That's fine. We can grant that or stipulate to that.
you stipulate to that, the court will grant it. You can comment on what you believe the evidence will show in terms of poor investigation or good investigation. Well, states can't argue really, or cannot. In opening statements is what you believe the evidence will show, not argument. So in opening statements, what you believe the evidence will show.
Yeah, I think, I mean, we're asking the court to deny the number 10 in total. Both parties, especially during closing arguments, the state and the defense can comment on this particular investigation, how it was performed. They're asking for any generalized comment regarding the police misconduct, like all, I guess I didn't quite understand what they're trying to keep out.
Well, what they're trying to keep out is that this is, there's no evidence of any misconduct by the police. And so that would be an improper argument. You can talk about what happened or didn't happen in this case. I think that that's the gist of what the state is.
Yeah, in this
Probably
case,
is.
right, how, exactly.
Okay,
I guess no objection to that, but
all right, so that'll be granted. 11,
Says the defendant should be prohibited from testifying through voir dire, opening and cross.
it's doing what? I'm sorry?
Testifying through voir dire, opening and cross examinations of the state's witnesses. Defendant should not seek to admit facts that the defendant would need to testify to, and then he doesn't testify.
Yeah, that would be, I would have an issue with that.
and we're not asking, we're not contesting that, but there's another part of it we are. Embedded in section 11, defendant may, in the state's motion, defendant may be impeached with his prior convictions.
Mm-hmm,
The only priors he has are juvenile conviction, and that, under Nelson v. State would not be admissible.
Right, we understand that.
you understand that
And
you
if
could
he
not
does
impeach.
testify, they can't ask him about anything.
Right, you understand that, correct?
Of course.
All right. So it's granted in part and denied in part. Everything, every ruling is without prejudice. Obviously, it depends on what I hear at the time, so they're subject to being revisited. Number 12.
That's
13 is, 12 is granted 13.
state's asking that the defense be prescribed from making any reference to the fact that the law enforcement officers in this case didn't collect DNA or fingerprints from the firearm that was collected from the defendant. It was collected from his purse, and there was no need to do that. To harp on that fact would be to mislead the jury about the evidence in the case or the diligence of the officers.
Your Honor, I respectfully, I'm asking the court to categorically deny 13. What
All right, so
essentially,
theory of defense. What's your theory of defense?
our theory of defense is that he did not point the gun at the women.
All right, so it'll be
And the-
basically the credibility of these witnesses.
And
as
that
to-
the officers had access to footage to prove his case or exonerate him that had not been presented to the jury today. And now we are not necessarily going to argue DNA and lack of fingerprints. But that could change. And if we're prevented from arguing that, if the witness gets up there and says, well, I didn't find the gun on him or I found it somewhere else, I don't know, it could come out differently. We would be essentially prevented from arguing an entire avenue, a theory of defense, a different theory of defense.
I'm not understanding what different theory of defense.
Your Honor, lack of evidence, lack of DNA.
That's not a theory of defense. That's an argument.
It's an argument, right? And it's relevant to the instructions that this court's gonna give,
Mhm.
right? And so if we're prevented from making an argument based on what's presented in court, I believe that would be improper to just be similar.
Okay, well, he can explain, the witness will explain why they didn't do it. Why they didn't take DNA? You want to ask the question, you didn't take DNA from the weapon? No, we didn't, because we took the DNA, whatever their reason is. So what's the issue with that, counsel?
Judge, it would just be the state argues it would mislead the jury to argue that that's something that would normally be done in such a case when it's simply not, when something is.
No, that, again, based upon what your officers will testify to, whether normally, not normally, it wasn't done in this case. Okay, so they can argue it wasn't done in this case. Not what was done in other cases. Do you normally do that? No. In this case, did you do that? No. Why? You don't want to ask why, because he'll explain why, and it'll be because we didn't find that there was a need to do that. We had 3 eyewitnesses. That's going to be what I imagine the testimony is going to be.
Judge, I would like to point out that the defense has sought to prohibit the officers from saying what was on the surveillance video and seeks leave to also make speculative and incorrect statements about what was on the surveillance video that no one has.
Oh, you can't speculate as to what was, no one can speculate. It wasn't retrieved.
Correct.
Okay. He went,
I'm
you
not
have an
sure what
officer or officers who went and actually looked at a surveillance, is that true?
That's right.
Okay, and they made a decision not to retrieve it, or they went too late, whatever it was, whatever the reason was. But to offer speculation or to have the jury speculate, well, why do you think that is? You think it's because it showed this, or that you think it didn't show that? I think that would be an improper argument. What is he going to testify to as to what he observed? Or is he going to testify to what he observed on the video?
Honestly, Judge, the officers we plan to call, I don't believe observed the CCTV themselves, but the other officers that did testify in their depositions, that it showed the car accident, but it did not show the criminal conduct.
Okay, so what are you planning to do with that? I need you to speak up really
Yes, I'm sorry,
loud,
I'm here. I
counsel.
can speak up.
All right, go
Very
ahead.
loud house. I suppose the officer who was the one who went to go see the CCTV footage,
Okay,
that officer didn't remember anything that was on the CCTV
Okay.
footage when I deposed her. So we have no reason to believe that there would be any inculpatory or exculpatory. We're fine with just saying that it was just not collected. The issue
Okay.
here is that is completely independent to the fingerprints and the DNA, because in this case, the fingerprints and the DNA is important because it's not just on the gun, it's also on the bullet that was found in the middle of the street. We have no fingerprints and no DNA to that bullet. So it was
Okay.
a random bullet in the middle of the street. We should be allowed to argue that no DNA and no fingerprints were taken.
that's fine. I don't have any
Okay.
problem with that. It's there. That's what they found. Did you do DNA? No, we didn't do it. Okay. And they'll explain that why.
We are not, with respect to the video, we're not gonna state or represent that the video showed a certain thing. It's not here, but there are reasonable inferences to be made about lack of evidence generally, as when a video had existed and it's not been provided. That the state didn't meet its burden in that sense. There is video evidence, it's not been provided, and that is a completely appropriate avenue of argument.
Well, multiple officers have confirmed that it didn't show the criminal conduct, and that's why he wasn't collected in connection to this.
There's a reason why it wasn't collected, and that's it. That's the end of it.
We have the ability to, I believe we should have the ability to explore why it wasn't collected, right? And present an argument accordingly.
And in that case, the officers will have to say what they saw on the video,
That's right.
or what was seen by other officers on the video and told to them.
Well,
If you start to go down that route, that's the response you're going to get.
I understand, Your Honor, but I'm keeping it general here, right? I'm not diving into specific
Okay.
questions. So as to 13, we're asking the court to deny it.
I don't see how that's a theory of defense.
Lack of
Well,
evidence is-
an argument, yes, you can make that argument, but it's couching it as a theory of defense. I'm granting the state's motion. However, you can always ask questions and make arguments applicable to your theory of defense, which you already stated to me was that your client didn't point a gun at anyone.
Correct.
Okay,
And that and there was a complete lack of thoroughness in their investigation.
okay.
Number 14, Judge, we discussed during pre-qualification last week.
I'm sorry?
Number 14, we discussed last week. That was in response to the defense seeking to admit the internal affairs profiles of the police officers.
Yes, that's not coming in. 15. Counsel, if you're going to speak from there, you're going to have to yell.
Just so that for judicial efficiency, we have a motion for the court to take judicial notice of the standard operating procedures and see a motion seeking to admit the internal affairs. We're withdrawing both of those.
Okay, that's fine.
And Your Honor,
Commenting on the evidence in opening, as opening statement, what you believe the evidence will show or not show, not closing argument. You don't make closing arguments in opening statements. You understand that? So
Judge, number 15 on the state's end was a request to prohibit the defense from minimizing the impact of the assault. That would be to mislead the jury about the law. There's no effect other than a well-founded fear in the mind of the victim that the defendant can make good on the threat that has to be shown. It shouldn't be argued that this wasn't a big deal or that it's an assault, but it wasn't really a bad one, because that's akin to asking for a jury pardon.
Yeah, there's no good or bad assaults. The law is the law. Okay, that's it.
And Judge, and this, we have three supplemental requests that I would like the court to take a look at.
All right, state, you're not gonna make an argument, justice for the victims or the community. That's an
No,
improper.
Judge, the state's aware that we can't.
All right, so that's granted.
The court's already ruled on number 2, so number 3 is the last one.
State's familiar with the law.
Yes. I'll give them the reasonable doubt instruction and the court, and again, I'm responsible for instructing them on the law. All right, what else do we have?
There's a supplemental motion for order limiting that was filed back in April last year during
Mhm.
COVID. There's 3 prongs to this one as well. The first one, we're asking for the court to enter an order.
You
prohibiting-
can't shift the burden. They don't have to produce the CCTV or comment on failure to produce evidence. Okay. That's granted. Mr. Sinatus was what? Oh, that he was impaired or is there going to be any testimony like that? Because that would be uncharged crimes. All right, that's granted. Independent proof of corpus delicti.
Any of that, Judge?
All right, so you understand number 3 as well?
I actually don't think I have a copy of this, Judge.
All right, so I'm not sure. Post Miranda statements of your client where there was an admission to possessing a firearm?
That can come in. That's not the
Yes.
objection, right? But it's that the admission to possessing the firearm has to come in after they've met at least met a prima facie case against the defendant. And they have to at least prove the body of the crime before they can introduce a confession to that crime.
Explain, I'm not sure I understand what
Okay.
you're saying.
So the elements of the crime, there has to be some evidence of that a crime was committed, right? That this crime
Mhm.
was committed
Mhm.
before any confession gets brought in. So, for example, if
No. In terms of order of evidence, ultimately, the state could not simply prove the crime. Well, here, it's not just possession of a weapon.
correct,
Okay,
and that's all I'm trying to
all right.
clarify.
They can introduce evidence subject to being linked.
Of course, but it's just, it can't, the admission to possessing the firearm should not come into evidence until they've asserted the actual elements of the crime and made a case about,
Okay,
so then evidence adds to the crime's charge.
I think that the state can present their evidence in the order they wish to present it, and you'll make objections that you think are appropriate at the time. So I'm not going to limit or restrict or prohibit the state in the way that they introduce evidence. Who's going to be your first witnesses?
The civilians, Judge.
Okay, that answers that question anyway. Because I'm assuming from that they're going to attempt to establish or present evidence of an assault. Okay, But it's simultaneous because what enhances an assault is the issue of the firearm. That's what aggravates it.
And Your Honor, we did, I don't know if the court is prepared to have pre-marked exhibits. There was a stipulation reached before. I don't know if the court wants to address that now.
You can do it during the course of, I mean, if you stipulated, documents will be introduced as stipulated. So let me hold on a minute. I just want to check to see what's taking the jury so long. Audio. All right. I'm Judge Tinkler Mendez. I welcome you all again to the courthouse here for jury duty and jury selection. This is essentially part 2 of the selection process. We had a preliminary jury selection last week. Several of you who are here today did not appear for the virtual jury selection, and therefore we asked you to make sure that you would be here today for the in-person voir dire. We are continuing to do our best in terms of health, safety, and welfare of all of our participants here. Masks are no longer mandated or required in the courthouse. However, we suggest that if you have not been vaccinated, that you do wear a mask for the safety of yourself and those around you. In addition, if you wish to continue to wear your mask, perfectly fine that you do that. Matter of comfort. And we want everyone here to feel comfortable. All right. Now, is there anyone here right now sitting here does not feel comfortable sitting where they're sitting? Because I will move you. I will move you to the other side of the room and you'll maintain your juror number. Now, your numbers, by the way, you were each given a juror number. Okay, and I'm going to go through those numbers with you. We're going to do a roll call here. All right. Ms. Susan Franco, number 1. Zaida Rodriguez Carrillo, number 2. Okay, all right, hold on a moment, madam. Patricio Gant, number 4. Doris Figueroa, number 5. Alicia Ramos Perez, number 6. Javier Rodriguez, number 7. William Hay Southwell, number 9. Diana Fernandez, number 10. Concepcion Valderrama, number 11. Isabel Cabrera, 12. Miguel Piloto Viamonte, 13. Jonathan Grindel, 15. Humberto Velasquez, 16. Maciel Fernandez, 17. Gabriela Perez Lago, 20. Hannah Dykes-Hearn, 22. Sorry. Jacqueline Cabrejas, 23. Maria Fernandez, 24. Mackenzie Lubin, 25. Brian Romero, 26. Rebecca Chanella, 27. Jose Donis, 28. Priscilla Gibbs, 29. Ron Ibanez, 32. Victor Cruz Lugo, 33. Santiago Perez, 36. Jorge Ramirez, 37. Catherine Ortiz, 38. Nancy Berwick, 39. Clarence Hodges, 40. Martin Moncrief, 43. Javier Gonzalez, 44. Joanna Klein, 46. Amanda Alfonso, 47. Norman Lopez, 48. All right, very well, thank you. Okay. Now, I welcome you all again. Serving on a jury, ladies and gentlemen, and I'll get back to you, gentleman who raised his hand. Serving on a jury is perhaps the most important thing that you can do as citizens in this country. There are only a few things that we're required to do. One is sit on a jury when called, and 2 is pay your taxes. So there's not a lot our country requires of us to be good citizens. This branch of government does not function, ladies and gentlemen, without all of you, without the people participating. and engaging in the process. That's why we require your presence and participation to serve on juries. It is absolutely critical to the functioning, again, of this branch of government, basically to the entire function of government. This is the only place, ladies and gentlemen, that you, as a citizen, have a voice, a direct voice. And we conduct trial proceedings with members of the community like yourselves who are here to make sacrifices, to be present, and to participate. We know it's an inconvenience, it's difficult, but again, this is a very short trial, so there'll be a limited few days that we're going to ask you to serve on this jury if you are selected. Today, for the next couple of hours, we'll engage in jury selection. I'd like to have you finish with your jury selection by about 2 o'clock this afternoon. We're going to keep moving forward. And we'll probably have to take a lunch break. We'll see if I can get things moving along so that we can get you in and out of here even prior to taking a lunch break. We may just take a quick snack break or stretch break so that I can get you out of here relatively quickly. All right. Now, there's a gentleman in the back who raised his hand, and that is please tell me your name. Speak as loud as you can, sir.
Thank you. My name is Jose Gomez. I'm number 28.
All right. This is Mr. Donis. And also I'm going to ask Robert, I don't know if you have, if we can get a copy of, not a copy, if we can get a microphone, a portable microphone perhaps to use. I'd like to be able to use that if we can, because again, it's a little difficult in this room and I need to have everyone's voice loud, please. All right, Mr. Donis. Let's see, would you like to come and sit over here, sir?
Your Honor, if I may, I am part of the hearing and I have hearing aids.
Okay,
And extremely sound was.
it's very difficult for you, I imagine. Well, let's see, what is the best place for you to sit that you would be more comfortable?
I don't know the reverberation of this room. Anywhere close would be fine.
Anywhere close? All right. That's a little closer. We'll move you there, Mr. Donis. All right, and then you guys in the back there can kind of spread out a little bit. Give yourselves a little space between each other. Okay, we sort of had these marked out for a couple months ago when we had the mandated 6 foot. As you can see, the taped 6 feet on it. But so now use your judgment here and give yourselves a little space between each other. All right. Okay. And if anyone, again, at any point has any concern or feels uncomfortable, we will accommodate. We're going to work with you. Okay. We have had a number of jury trials already here at the courthouse, although we have been managing in a different way. But I still want to try to keep everyone comfortable, of course, and you need to tell us how you feel. Okay, so let's continue on. All right, so there's a gentleman here, Mr. Velasquez. All right, Mr. Velasquez, I see you brought a letter in with you today. And I understand you are 75 years old. And did you, were you present during the virtual voir dire? No? Okay, all right. Mr. Velasquez, I can't excuse you because you are over 70. Do you wish to be excused, sir? Okay, well, did you write this letter, sir? Or did someone else? All right. All right, so Mr. Velazquez, if you wish to be excused, which is apparently what your wife wishes for you. I don't know if it's your choice, but it seems like she would like that. Let me, okay, let me say this to you. Unless you're 18 years of age or younger, anyone can serve on a jury. While at the age of 70 or over, you have an option. I'm going to tell you that one time we had a juror who was 96 years old, and he had never served on a jury before, and he begged to be on the jury, and he wound up getting selected on the jury, and he wound up actually being chosen as the foreperson in that case. It was the most moving for me as a judge to hear this man speak about the experience for him. It gives me goosebumps now to talk about it. It was so moving for how important it was to him as a citizen in his life to have the honor of serving on a jury. So having said that, if you would like to stay, you're more than welcome. Okay? Okay. I'm not trying to talk you into it or out of it, but that's what the letter says here, but it's your option. Okay? All right. So ladies and gentlemen, let me spend just a couple of minutes to talk to you about this selection process. The jury selection process is one of the most critical parts of the trial. The reason for this is because we need to select a group of individuals who we believe can be fair and impartial and will make a decision about this case only based on the evidence presented in the courtroom and the law that I will give to you. You all come here with your life's experiences, common sense as well, okay? We can't, and we're not trying to change who you are and what you think about things and how you think about things. But to do the job here, there are very specific rules as a juror that you must promise to follow. And we ask you to do that. We're going to give you that job description, the parameters, the blueprint for the work that we're asking you to do. You need to tell us honestly and openly whether you can do the job. Now, you may not want to because it may be inconvenient and difficult, but guess what? You're all here now. Okay? So you're here to do a job, and we need to know from you during this selection process whether you can do that job. Because we have to rely on your decision as a fair and impartial decision. So that's why we go through this process. It works best if you communicate with us, if you speak with us. I'm going to ask you also, again, it's very important. You may want to stand up so your voice is projected. Speak loudly and clearly. Be honest with us. Raise your hand if you have a comment, even if you're not being called on. We prefer for you to respond. Okay, gentlemen here. What's your name, sir?
Jonathan Grindell.
Mr. Grindell, yes, sir.
This isn't like a super pressing matter. I just thought I'd get it up there. I'm trying not to let my nerves get the best of me.
Sure.
I'm really nervous. I'm 21. I'm really young still.
Yeah, this is,
I just registered to vote the first time.
all right.
But I just thought I'd make a comment. Trying not to get my nerves.
Hey, listen, you just broke the ice. And I want to say thank you for doing that. You know what the number one fear people have? Who said it? Yeah, that's Miss, what juror number are you? Juror number 29, public speaking, Miss Gibbs, number one fear. And you know, I gotta tell you, it's so great that you spoke. And we're not here, by the way, to embarrass anyone. We're not here to make you feel uncomfortable. I'm going to explain the process to you. We're going to try to make it easy for you. Okay? Your participation, though, is absolutely necessary. How many here have ever served on a jury before? Just raise your hand. Oh, only a few people. A few people. Well, you've been through jury selection. Some of you have been through jury selection process, so you've had an idea. And thank you again for allowing us to bring you back. Could have been kicking and screaming, but you're here. And for the rest of you, it's a new experience. So thank you again for your patience and understanding. Let me go into the rules of the house with you, just give you that outline of what we expect you to do here in order to do your job lawfully and fairly. And, you know, I made a lot of introductions, I think virtually, but it's a little different live now, right? We actually see each other. So what I'd like to do before I even get into the rules of the house is kind of reintroduce everyone. You've already met my bailiff, Robert. He's in and out. You met Gus also, the other bailiff who's assisting us. I'm going to ask, ask the parties to announce case is the state of Florida versus Wolf Senatus. I'm going to ask the parties to announce as well. But first, let me introduce my clerk, Chris, sitting right here. My court reporter. Okay. And the parties, would you announce, please?
Good morning, everyone. My name is Lindsay Johnson. I'm the Assistant State Attorney, and I represent the people of the state of Florida.
Good morning, everyone. My name is Nisha Kumar. I'm also an assistant state attorney. I also represent the people of the state of Florida.
Hello, everyone. My name is Conrad Clifford, and I have the pleasure of representing Mr. Sinets.
Good morning, everyone. My name is Karen Jordan, and I have the honor and privilege of also representing Mr. Smith.
Okay. And my court reporter has a name. I'm so sorry, Yasser, sitting right here. I would like, why don't you introduce him properly? Hi, Yasser. I'm going to ask my clerk, Chris, to please swear you all in. If you'd stand, raise your right hand, please, and face my clerk.
You solemnly swear or affirm you will answer truthfully all questions asked of you as prospective jurors. Please say I do.
All right, very well. Thank you, ladies and gentlemen. So let me go over these rules of the house with you, okay? As you know, you're in a criminal courthouse. This is a criminal case, all right? And in every criminal case in our country, the person who is accused, in this case, it's Mr. Senatus, is presumed innocent. You see, jury trials are the only forum, only place that these issues can be resolved. Mr. Senatus is innocent. He hasn't committed any crime. He's been accused of a crime, but he is innocent. He is presumed innocent. That's what the law says. That's what the Constitution says. That's what protects all of the citizens, all of us. Anyone accused of a crime, presumed innocence, fundamental principle and rule of this house. And you must continue to presume and believe that he is innocent, not guilty of any crime throughout the entire proceedings. unless that presumption is overcome by evidence sufficient to prove guilt beyond and to the exclusion of every reasonable doubt. And I'm going to explain some of these terms to you. Legal phrase. But that man is innocent. And you can't think anything other than that. He sits here accused. And this is the place that you as the people determine whether or not that man is guilty of any crime. Okay? Second, to overcome that presumption of innocence, the state of Florida, they make the accusation. They must prove it. They must present the evidence. Their responsibility is to do that. And their responsibility is to present sufficient evidence beyond and to the exclusion of every reasonable doubt. I'm going to read you the legal definition of reasonable doubt. Ladies and gentlemen, at the end of the case, if you are on the jury, you will get the legal instructions, the law from me at the end of the case to actually take with you back into the jury room, to have with you when you're making your decisions. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in the trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. That's the legal definition. Okay? So, very important rule of the House, burden of proof means responsibility of presenting evidence beyond and to the exclusion of every reasonable doubt. That's on the state. And it always stays with the state throughout the entire proceedings. It never shifts to the defense or to the defendant. Never becomes their responsibility to do anything. This is the forum that the people that are making the accusation must come to the citizens to prove the citizen committed a crime beyond and to the exclusion of every reasonable doubt. Mr. Sinatus has no burden whatsoever. He doesn't have to testify. He doesn't have to present witnesses, evidence, nothing. They can sit there. His lawyers can sit there. They can do crossword puzzles. It's not going to happen likely, but to make the point, the responsibility entirely rests with the party, the state of Florida, because they make the accusation. That's what our Constitution says. That's how our citizens are protected. And this is the place where we have these proceedings. And that responsibility, or burden, as we say, of presenting evidence always stays with the state. As I said, Mr. Sinatus doesn't have to present any evidence. He doesn't have to prove that he's not guilty of any crime. He doesn't have to disprove guilt. The state has to prove guilt beyond every reasonable doubt. And in that regard, again, he doesn't have to present any evidence. He also doesn't have to testify. Fundamental rule of this house. Okay? Fundamental rule that you have to follow. That man does not have to testify. He's innocent. And if he chooses to exercise his right not to testify, you can't consider it. You can't hold it against him. You can't speculate or wonder. Because if the state fails to present sufficient evidence beyond a reasonable doubt, two things: one, that a crime was committed, and two, that Mr. Sonatas committed a crime, your verdict must be not guilty. Okay? He doesn't have to testify. He doesn't have to do anything. Now, let me tell you something. The rules of this house are very, very specific to these types of proceedings. We're telling you here, to do the job, you have to promise to follow these rules while you're in here. You may have other rules in your own house. Let me give you an example. It's kind of silly, but I think it makes the point. How many of you have children at home? Couple of you? All right. If you don't, just imagine this. Okay? You've come home after a very exciting day of jury selection here at the Richard Gerson building. And you get home, and sitting on the couch in the family room, your children are sitting there and they're watching television, and your coffee table, there was a really pretty vase that you had on that coffee table that's now on the floor in 1,000 pieces with a soccer ball laying next to it. Now, does the right to remain silent work as a rule in your house? I see a lot of people shaking their head no. I make that point, it's kind of silly, but it's important for you to understand. You can have your rules in your house. But to do the job here, you have to promise to follow these rules. Or otherwise, the decision is a miscarriage of justice. We're counting on you to make sure you focus on and only follow these rules of this house. Okay? You may not even agree with them, and that's okay. You're entitled to your opinion, but you have to take this like you would take any job and responsibility. That important. At your job, there's certain requirements to do X, Y, and Z, and if you vary from those, or if you allow your emotions or feelings or biases or prejudices to interfere, the job doesn't get done properly. Same thing here. You cannot base your decision on anything other than the evidence you receive in the courtroom and the law that I'm going to give you. And again, these rules of this house. Okay? That's what jury selection is to talk to you about this. We don't talk about the facts of the case, by the way, because that would cause you possibly to prejudge. We don't want you starting to think about anything, because we don't want you formulating any opinions about the merits of this case until after you have heard all of the evidence, the argument of the lawyers, and I give you the law. Only at the moment you step into that jury room together as a jury that's been selected can you begin to discuss the case and come to conclusions. Until that time, no. It would be improper. It would be unfair. We count on you to be fair. Look, this is not a perfect system. It's the best we know, though. So that's why you need to be honest and open with us. If there's something that we ask you or you want to tell us that you feel you want to speak privately, we'll arrange to do that privately. Okay, and that's fine. We can do that. And the gentleman there, I think that was Mr.
25.
Mr. number 25, Mr. Lubin. We'll speak with you privately. Again, we're not here to make anyone uncomfortable or embarrass anyone. We just need information so we can select the best jury possible for this particular case. Okay, now I have a document in my hand This is a charging document. It's called an information. It serves one purpose and one purpose only. It's to inform the individual who is accused of what the accusation might be. Not evidence, it's not proof of guilt, it's not proof of anything. It's a notice document. In this case, Mr. Sinatus is accused of 2 counts of aggravated assault with a firearm. Allegations, not proof of guilt, not proof of anything. And you can't consider it anything more than what it is, which is notice. Okay? All right. Now, I do have a few other just very preliminary questions because, again, some of you did not make it to the virtual pre-qualification where we would ask these questions and did ask these questions. Anyone here have difficulty with English and not following? All right, there's a young lady here, and this is Ms. Zaida Rodriguez Carrillo. Okay. All right. I believe that was any other individual here. All right. And anyone here not a citizen of the United States or not live in Miami-Dade County? Okay. Very well. Again, there were several things we did handle in preliminary, virtually, that we didn't handle with everyone because some did not appear. All right. Okay. Now, you'll notice also that the parties are not wearing masks. They're going to continue to keep a distance from you and speak loudly and clearly to you during this voir dire. If at any point, again, during the proceedings, anyone feels uncomfortable or would like some movement in their seat, just let us know that. Okay, as long as we can continue to identify you by your juror number and your name. I also want to point out, I believe we have several people with the same last name. So I'm going to ask you also to give us your first and last name. Okay, I see there's several with the name Fernandez. I think I have 3 on the jury with the name Fernandez, last name Fernandez. So, and I believe also, I think Perez, right, Chris? Perez Lago was one and Santiago Perez was the other. So again, give us your first and last name as we go through the jury conversations with the attorneys. All right, very well. I'm going to now have the state begin with the voir dire.
Good morning, everybody. Thank you so much for being here today. I know nobody really likes to be called into jury duty. Maybe a few people do. I'm sure we probably wouldn't mind. Maybe defense counsel wouldn't mind either. This is what we do. But we're not going to take up too much of your time today, but we do have some things to discuss that are really important. Because we need jurors. In this case, we're going to be fair to both sides. That means no conviction if we don't fulfill our burden and prove our case beyond a reasonable doubt. That also means when we do prove our case beyond a reasonable doubt, that you convict in fairness to the state. So let's think of it as a mathematical equation. Let's say that a given crime that is charged has 4 elements. Every crime has elements. That's parts of the crime that you have to prove in order to prove the crime as a whole. So let's say we present to you fact 1, which proves to you beyond a reasonable doubt the first element of the crime. We present fact 2, proving to you beyond a reasonable doubt of element 2. We present facts 3 and 4, which prove to you beyond a reasonable doubt elements 3 and 4 of the crime. Element 1 plus element 2 plus element 3 plus element 4, all beyond a reasonable doubt, that equals guilty. Mr. Romero. Good morning.
And what's your number, please? Okay, thank you.
So let's say we present fact 1, fact 2, fact 3, fact 4. You believe we've proven all 4 of those beyond a reasonable doubt. What's your verdict? Good. Right. Is there anything to consider after that? Number 1, number 2, number 3, number 4. Right, we have the total there, right? So if selected to be on this jury, your only job, lucky you guys, next couple of days, if you're selected, you only have one job, is to decide whether we, the state of Florida, have proven the elements of the crimes charged beyond a reasonable doubt. You're just sitting in judgment of the facts. You don't have to worry about the law. That's what the judge is here for. You don't have to worry about any morals or ethics or values, just the facts. There's no more math to be done. 1 plus 2 plus 3 plus 4, guilty. Very easy. But let's talk about some of the things that tend to distract some people from that simple math. Some people, due to their system of morality or their religion, might have just a blanket standing issue with sitting in judgment of another person. Now, like I mentioned before, I understand that it's not everyone's favorite way to spend a couple of days in jury duty, but I don't want anyone to use this question. Yeah. I promise, if you're selected to be on this jury, you're gonna feel a little vindicated by that. So, is there anyone here who would say that they have a religious or deep-seated moral objection to sitting in judgment of another person no matter what?
Well, let me qualify a little bit. The question is, you will be making a determination as to facts and evidence. Okay, all right. What's your Miss?
Figueroa, number 5.
All right, Ms. Figueroa, what is your concern, ma'am?
I belong to a church, I'm Catholic, and I'm very active. So
No, and that, I'm sorry, I didn't mean to interrupt you, ma'am. And understanding that, and you're not in judgment of an individual. Here, you're in judgment of facts and evidence.
Yes.
All right?
But I do believe in the mercy of God and Jesus. How do you think Jesus is gonna think? That's how
Understand. Understand. Okay.
Thank you for telling me.
Mhm.
And, you know, again, please, in your answers, don't be worried about what we're gonna think, what anyone else is gonna think. We're just after honesty. We want to select the best jurors for this case. Mr. Lubin, I saw you just raise your hand.
Okay, Mr. Lubin wants to speak with us about something privately, so we'll talk with him privately. All right, go ahead, Counsel.
Gibbs?
I'm very opinionated and I'm strongly.
And this is Miss, I'm sorry,
Is
Miss Gibbs, yes. Mhm.
regarding certain social issues. Daughter's attorney and I grew up in everything, so while I can serve, I definitely very emotional person.
Let me ask you, Miss Gibbs, what kind of work do you do? Yes, what kind of work do you do, madam?
Customer service, usually it's, for a while it was Starbucks barista, but once
Right.
I I was living in New Jersey, I moved in here, my mother has cancer, so,
Hmm,
I got a job for a little bit, but, I was on unemployment for a while.
Mhm,
That's current.
and, absolutely, we understand, and it's good to have opinions about things and thoughts and interests in, you know, the things that you're describing, social issues. But on a jury, your decision can't be based on opinion. It has to be based on evidence, and only the evidence and the law. One of the instructions I give you is you must follow my instructions as a whole. You cannot ignore or disregard any one instruction of the law. So the question is, as a juror, sitting here and understanding that we're going to ask you to follow the law and the rules of this house to do this job. All right? Think of yourself in a job you may have had, or, you know, at some point in the past. There are certain requirements of that job, and it has to be done a certain way in order to get the result, the correct result. So you don't need to do away with your opinions or disregard them, but your opinions cannot influence your decision where there would be a miscarriage of justice. For example, let me give you an example. Let's say the case had to do with possession of marijuana. Okay, individuals charged with possession of marijuana as a crime. And you have very strong opinions about whether that should be against the law or not against the law, or you're very involved in that. Those opinions, if they were going to prevent you from making a decision based only on the law and the evidence presented. For example, let's say in that case, the state presents sufficient evidence beyond every reasonable doubt to your satisfaction that a crime was committed and the person accused committed that crime of possession of marijuana. But because you don't think that that should be the law, you find the person not guilty. That would be a miscarriage of justice. You see? So that's the point I'm trying to make here. So think about that, and then we'll come back a little bit and talk about it with you, okay? Go ahead, counsel.
So, similarly, some people, just as a feature of their personality, or maybe what they do for a living, their experiences in life, they might be more focused than others on the ideas of forgiveness, second chances, mercy, like someone just said, rehabilitation. And that's a beautiful trait to have. There's absolutely nothing wrong with that. But what we want to make sure is that these feelings, these aspects of some people's personality don't get in the way of their ability to focus on the facts and follow the law.
Because if the jury finds, in this case, Mr. Sanatas guilty of the crimes that he's charged with, it is not for the jury to determine a proper punishment. That's the court's responsibility. So you cannot be thinking anything about the what if or what happens next. It's not your job. Your job is very focused and very clear. Your job is to determine if there is sufficient evidence beyond every reasonable doubt, one, that a crime was even committed, and if so, if Mr. Sanatas committed a crime. That's it. Okay? Go ahead.
Took the words right out of my mouth, Judge. So, you know, maybe you want to assume the best of someone who's been accused of doing something terrible. Maybe you might find yourself thinking, surely this person regrets it. We all have bad days. We were young and stupid and did something dumb, that's all. Maybe you're thinking, if I was a victim in this case, I would just forgive and we can all get on with our lives. I think that would be best. Maybe you're thinking, I don't know if I agree with the law that this person has been charged with raping. These are the kind of thoughts that you must put aside when reaching your verdict. All that's going to matter from where you're sitting is the facts. Have we proven every element of the crime charge? If we have, there's nothing more to think about. Again, we won't be deciding any punishment if the verdict is guilty. We shouldn't be speculating about what the punishment might be. There's a wide range of things that can result from guilty verdicts. In this state, in this county, in this country, this is not your job to think about that. Just the facts. Ms. Perez Lago, is it going to be your job to decide whether the defendant should be forgiven or given a second chance? Sorry, do you answer? No, shaking your head no, okay. Right, exactly, not your job. Just judging the facts, the proof. Ms. Valderrama?
Yes.
Should you allow any of these feelings or thoughts that I just kind of listed off there to decide or to factor into your decision about whether or not the state has proved its case?
No.
And will you not allow that to happen if it's selected to be on this jury? No. I know that this undeniably sounds harsh. I understand that. There's no way around that. But it's important, because like I said, in addition to fairness to the defendant, fairness to the state and to the laws that we enforce. The laws must apply equally to everyone. How do we make sure that happens? Mr. Ramirez, how do we make sure that happens, that the laws are applied equally to everyone? In your role as a juror. Exactly. I'll make it even simpler. Two things. Focus on the facts and follow the law. That's all any of you need to do. That's how, as a jury, you can be fair to everyone involved. Focus on the facts and follow the law. Your opinions about the defendant, victim, the situation, what the most desirable outcomes might be, in your opinion. You must leave those thoughts and opinions outside the deliberation room door if selected to be on this jury. Is there anyone who thinks they would not be able to do that? Ms. Franco?
I tend to agree. I think that gives the juror that's spoken more about social issues. It's looking in the room. And the defendant, right? And I'm already looking at the disparity of circumstances. And I'm already, my thoughts are just not going to be. It's been a tough year for everybody, and I'm a very social person, and I am completely left, and I just don't think I can be together with going through religious.
Okay, so you're saying you wouldn't be able to focus on the facts and follow the law
I
if
don't know
it,
if I could. I don't know if I can.
thank you for being honest.
For me, my issue is not more so private for me, but I don't want to protect the rest of the room with what I have to go through. So I don't mind sharing it, but that's the reason why I first preliminarily said I'll share it. in private, but I don't mind. It's up to you guys.
If you want it to be private, the judge will
It's
hear how the
not,
attorney.
for me, it's fine. I don't mind sharing it. I just didn't want to affect her. Why I have to say it. So that's up to you guys.
All right, well, what was the question in particular about, though? I'd rather we speak in private, sir.
Okay.
All right?
Mr. Riddell?
I agree with you. I just, I said earlier, that my parents get the custody of social situations. And also my sister and aunts are both lawyers. When I listen to what they have to do sometimes in their work, I usually tend to second guess myself and everything that's around me a lot.
And you raise an interesting point, really, because, what I want everyone to understand also is that what the lawyers say, that's not evidence. Ultimately, it's going to be whatever the witnesses say, come out of the witnesses' mouths, whatever's presented to you. Your job as a juror is going to be to determine the credibility, the believability of the information you're receiving. And I'm going to suggest that you do it all the time. You don't even realize that you're sizing people up all the time. When you have a situation, you're faced with a question, someone presents you with information, you decide whether or not you can rely on that information. So these are some of the skills that you have that are subconscious, that you use in making these determinations about the information that you're going to receive. Okay, and you have to sit and you have to wait until you gather all the information. And at the end of the case, after you're given the law, that's when you go and you communicate with the other jurors that are selected and come to a conclusion. Let me ask you, Mr. Grindel, are you in school? Are you working? What do you?
Yes, I'm both. I'm a full-time student. I actually took the midterm from the student.
Oh, good.
I have a part-time job in customer service.
Customer service?
Yeah, and also actually, I just got hired a few months ago.
Fabulous.
That's got me my anxiety a little bit also, just working with people.
Sure, that's a big, it's a big responsibility, but it's also, I think it'll, in time be helpful. And, again, this is a pretty overwhelming experience for anyone. So don't feel you're alone at all in being, nervous or uncomfortable about expressing yourself. But, as counsel asked, do you believe that you can listen to the evidence, keep an open mind, and ultimately make a decision based on the evidence and the law?
I feel like I could say yes, but I wouldn't know until I was actually in a position.
Sure, sure.
In general, I was speaking like, when I said earlier, that's how I feel in general. Sometimes when I look up things on the news or see things around me, I tend to do like, a lot. So,
They're very, they'll impact you,
right.
absolutely.
And based on what I hear, hearsay and stuff like that, it's just something.
Yeah, you're using a phrase that will, legal, and that's the thing. What are you studying in school, by the way?
I'm actually in criminal justice.
Oh, wonderful.
So I actually need to break this exponential thing, but, at the moment I can't help but feel a little nervous, but yeah.
Sure.
It's just something that I feel, I can't get that out of my character, feeling.
No, that's personality and people respond to information. All right. But this trial you can only look at, because it would not be fair, right? Let me put it out there. The elephant in the room, you've heard a lot in the community about firearms recently, right? Gun violence. Okay. Mr. Sonatas should not suffer prejudice because of what you might hear in the community as a hot topic. People are stressed about that. Okay? That's not his responsibility. You see? So it would be unfair to judge him based upon things you may see in the news or hear about. And that's what you have to focus on. Okay?
Anyone else think that they would have an issue leaving those feelings, those worries at the door if selected? Ms. Rodriguez, you'd be able to focus on the facts and follow the law?
Yeah.
Mr. Perez, you'd be able to focus on the facts and follow the law?
Now, you say Perez, but there's two of them, so that's Mr. Santiago Perez. All right.
So similarly, some people are going to find it difficult to convict after the state has proven the case beyond a reasonable doubt, because the potential consequences to the defendant might weigh heavily on them, and the judge touched on this already. I just want to make sure you understand, we're not here to decide anyone's punishment. The judge does that later on. And she's going to tell you, she told you already, you must not speculate about that, what that sentence is going to be, because it cannot factor into your decision, and it is completely irrelevant to whether or not the facts of the case have been proven. So obviously, not knowing might weigh heavily on some people. Let me say this in the most gentle way possible. It shouldn't, it really shouldn't. Because it's not your responsibility to decide that or to concern yourself with it at all. Remember what I said? One job. Follow the facts, focus on the facts and follow the law. Is there anyone here who is not going to be able to stop themselves from taking that weight onto their own shoulders? Anyone I haven't heard from yet? And there's no judgment. Again, we just need you to be honest. Followed wrong. Be able to follow the facts and focus on the facts and follow the law.
I'm sorry, that is Miss,
Exception, hold on. 11.
okay.
Mr. Cabrera, likewise, you'd be able to focus on the facts. Mr. Piloto Piamonte, be able to focus on the facts and follow the law.
I can't hear you, sir. I'm sorry.
Yes.
Thank you. Okay, thank you, sir.
Ms. Fernandez, in the black room, you'd be able to focus on the facts and follow the law despite these personal feelings.
Is that Miss
Maria.
Maria Fernandez? Very well. Thank you, madam.
I'm going to move on to a few things that are a little more specific. If you're thinking about this more, and you say, you know what, I should say something, just raise your hand. You can go back to it. Because, like I said, it's important. Fairness to both sides. So, if selected to be on this jury, you're going to be hearing testimony about something that happened almost 3 years to the day in the past. Years is kind of a long time. Anyone have a pretty major life event about 2 years ago? One person? You don't remember every single detail about that event, do you?
My dad passed away.
Oh, sorry to hear that.
But I just remember it's
Let's say maybe you had a wedding 3 years ago. You graduated from high school or college or graduate school 3 years ago.
That's Mr. Grindel.
Yes.
Mhm.
So you might not remember what shoes you wore when you graduated, but you remember who was there in the audience to support you that day, don't you?
Yes.
Some details are more important than others. And the less important details, those are the ones that tend to fade away as time goes on. Your brain says that's not important for me to waste the space on it, out it goes. Is there anyone here who would find it difficult or impossible to find the witness credible if they don't remember every single detail of an event that took place 3 years ago? Well, let's talk a little more about witness credibility. Broadly speaking, there are 3 main types or categories of evidence. Does anyone know what one of those might be? Sorry, physical. Ms. Ortiz? Physical evidence, that's right. What might be an example of physical evidence?
Anyone have an idea what would be physical evidence?
The actual weapon.
Firearm?
A
Mhm.
weapon would be physical evidence.
And who is that, the young lady in the back?
Ms. Ortiz,
Miss Ortiz? Mhm.
038.
Thank you.
Mr. Southpaw.
I'm sorry, I can't hear the gentleman. Mm-hmm.
Recording. That could be considered physical evidence.
Audio, video recording? Mm-hmm.
How about another category or type of evidence? Ms. Gibbs.
Eyewitness testimony.
Testimony, that's right.
Like the least reliable one.
So there's no automatic weight or reliability assigned to any type of evidence.
That, and in fact, that's your job. You're gonna get an instruction on the law that says, how do you weigh the evidence? And there's a whole list of things that you can look to determine what weight, what significance, if any, you want to give to the information you've received, the evidence. Okay? You
I actually have a biased opinion on that because I listened to a study that actually showed.
Okay, don't hold that to yourself. Okay, we can talk privately about the studies that you've reviewed, okay? I know, but we'll talk privately. Okay, go ahead.
We have physical evidence, we have testimonial evidence. Anyone know the third kind? Mr. Lopez.
How about the fingerprints?
I think that would fall under the category of physical evidence. The third kind would be circumstantial. Now, that's a little hard to define, but what I want to talk about right now is testimonial evidence, witness credibility. Now, like we just said, there's no weight assigned to any type of evidence. And you can sustain a conviction of guilty on only one kind of evidence, that's all there is. As long as you find that the facts, the evidence.
The court will instruct you on the law. And to clarify, ladies and gentlemen, your role is to determine what the evidence is. It could be physical evidence, circumstantial evidence, testimonial evidence. Doesn't matter what is presented to you. You determine what it is and how much significance you wish to give it, if any. You look at it as a whole. You consider it. And if the state presents to you sufficient evidence to meet their burden of proof beyond every reasonable doubt, it does not matter the type of evidence you rely on in making this determination, as long as it's evidence. And that's what you get in the courtroom from the witness stand. Okay? There's not, one type of evidence is not more or less significant than another type of evidence. You determine its significance. Okay, go ahead, counsel.
So, right, only you can decide what weight to assign to a particular item of evidence, regardless of of other testimony, physical evidence, or the circumstances. That is all up to you. The requirements of any one time is the requirement of multiple times. Is if you find that the case is proven beyond a reasonable doubt, doesn't matter what kind of evidence it is, just that you decide the weight to it necessary to find that the presence of that fact proves that element of the crime beyond a reasonable doubt. Now, if the state presents a witness, Mr. Cruz Lugo, the state presents a witness and you find that witness to be credible beyond a reasonable doubt, can you convict?
Sure.
Right. Ms. Berwick, if the state presents a witness and you find that witness to be credible beyond a reasonable doubt, can you convict?
I'm sorry, that was Ms. Berwick? Yes, thank you.
Let's talk more about the specific offense charged in this case. As the judge told you, it's aggravated assault with a firearm. This crime has 4 elements. I'll read you what the law says. I'll break it down. Element number 1, the defendant intentionally and unlawfully threatened either by word or by act to do violence to the victim. 2, at the time, the defendant appeared to have the ability to carry out that threat. 3, the act of the defendant created in the mind of the victim a well-founded fear that the violence was about to take place. Number 4, the assault was made with a deadly weapon or a firearm, in this case, it would be a firearm. Number 4, the assault was made with a deadly weapon or a firearm. In this case, it's charged as firearm. It's 4 elements. We need to prove each one of those beyond a reasonable doubt. If we do, that's a conviction. Let me break that down a little bit. So first, the defendant threatened to do harm to somebody, violence. At the time, it seemed like he would be able to do so. And that threat, coupled with that apparent ability to do so, makes it the victim think that it was actually going to happen. They were about to sustain violence. And then, you know, the deadly weapon, firearm, I don't need to break that down for you, right? Mr. Doris, did you notice anything that wasn't among those 4 elements?
I do not.
Would you anything you might have expected to hear?
No.
All right. Well, you might notice that what is not among those elements that I just listed off is an injury.
I'm sorry.
Injury. There's no injury that's required. You don't have to show an injury to prove this charge. It's not one of the elements. Is there anyone that's going to have trouble convicting of a violent crime where there's no injury? Does anyone need an injury in order to be able to convict?
And the law, again, when I instruct you on the law, you have to understand, you don't make the law here. I don't make the law. That's a different branch of government that creates the law. I will instruct you as to what it is, and you must promise to follow it, even if you don't agree with it, even if you think it might be too harsh or too lenient. It's the law and you have to follow it. Okay? So when the council is talking to you about parts, elements of what the crime charged is, think of it this way. If you were baking a cake, you have different ingredients, parts. Okay? You need the flour, eggs, I don't know, what else?
Milk, butter.
Butter, milk, Depends if you're using a box like I do or whatever. Okay. If one of those parts are not there, like the flour, you're not gonna have that cake. Okay? Same thing with parts or elements of the crime. They all must be proven beyond and to the exclusion of every reasonable doubt. Does anyone have any question about that? Okay, the gentleman there, and that is Mr. Yes,
Are we to consider degree?
sorry?
Are we to consider degree? Or this case? I'm not sure.
No. The charge is, as I indicated, aggravated assault with a firearm. And these are the parts of the crime. And that's what has to be proven. Okay? All right, thank you. Okay, counsel, go ahead.
Mr. Hodges. If a crime charge does not include an injury, do you think it's just not that big of a deal? I'm sorry?
I think it's still crime, no, I don't have to.
Right, so an injury would not be necessary to be convicted. If you prove this needs to be on the basis of that.
Right.
Ms. Alfonso? There you are. Would you need an injury in order to convict someone of a crime? Mr. Moncrief, I'm sorry, am I pronouncing that correctly? Would you be able to convict, even though there's no injury, if we prove our case beyond a reasonable doubt? Anybody that would have trouble reaching a verdict of guilty just because there's no injury relating to this crime? I'm gonna move on to the last thing I want to talk about today, and the judge touched on it already, and she's gonna instruct you on it again, and that's reasonable doubt. There's a difference, like she said, between beyond a reasonable doubt and beyond all doubt. There's only one way to know something beyond all doubt, right? Is Cabreras. What is the only way to know something beyond all doubt?
Juror number 23, correct? Well, what is the only way that you could know something beyond all doubt? Can't hear you, ma'am. Okay, anyone else have a thought? The young lady next to you, that's Miss Maria Fernandez, number 24.
I would say the only way to have all reasonable identity is to be a witness yourself.
You gotta be there.
You would have to be there.
Then then there's no doubt, right? Then you can call it the absolute, because you were there. Then you wouldn't be on the jury. Okay?
You'd be witnesses, not jurors.
Okay? So the point counsel's making is it is the highest burden under the law, but it's reasonable doubt. Okay? It's not speculative, imaginary, or forced doubt. It's a doubt that's based in reason. If you have a doubt that is based in reason, that is reasonable doubt. Sounds like we're talking in circles. And that's a not guilty. If you have a doubt based in reason. If you have no doubt based in reason, then that verdict is guilty. I'm simplifying, but again, I read you the instruction and that's what you must follow at the end of the case. Go ahead, counsel.
So just because something is technically possible doesn't mean that it has reasonable doubt. So when something is technically possible, but you really have to for yourself say, I guess it could have happened that way. You might not have reasonable doubt there. That might be a forced doubt. of the difference between a reasonable doubt and a forced doubt. It's a very subtle and abstract difference. And every single one of you knows exactly what that difference is. Because you decide, it's intuitive. You know what reasonable is and what it isn't, because how you perceive it. So there's a couple of examples I like to give just to illustrate this difference, though, just so we can think about it more abstractly. The judge gave a hypothetical scenario earlier about small children. So people had small children here, right? So, Perez, nodding? Do you have small children?
No.
Oh, sorry, I misread your bio. Okay. Anyone have small children? Mr. Piloto, Villamonte? So kids probably aren't allowed to have sweets before dinner, right? Yeah, ideally they wouldn't have sweets before dinner, right? So let's say you are making dinner one day, one of the small children approaches you and they have Oreo crumbs all over their lips, unmistakable, dark, black in their teeth. You start to admonish them a little bit, like, oh, Junior, you're not supposed to have cookies right before dinner. I'm making you some broccoli. You can have the cookies after. Then they say, Dad, I didn't eat any cookies. Somebody left some Oreo crumbs on the floor in the living room, and I tripped, and my face landed on the floor, and they got stuck. Kids are sticky, right? Stuff sticks to them a lot. It could have happened that way, but does that sound reasonable? A reasonable explanation to you about why there's cookie crumbs? No, right? Could have happened, but come on. Exactly, okay. Another example, Mr. Lubin. Do you live in a house or an apartment building?
Oh,
Own a house, awesome. So let's say you go outside your house one morning on your way to work, you see the grass is wet, the house is wet, your car is wet, what do you think happened? Rain, right? That would be a reasonable explanation for why all those things are wet, right? Does everybody agree? Let's say your neighbor comes out and is like, darn it, those police, the firemen went rogue again, and they drove down our street last night and must have sprayed everyone's houses with fire hose. Is that possible?
Yeah.
Who's gonna stop them, right? Is that a reasonable explanation for what happened?
I agree.
Do you think that's a reasonable explanation for why the house is wet?
But because of the rain.
No, the fireman came down the street with the fire hose. No, it's a little nutty, right?
Overruled.
Is there anybody here who thinks they might have a hard time distinguishing between a reasonable doubt and a forced doubt? Has anyone been thinking about the questions I asked a little while ago and thinking that they might have a hard time focusing on the facts and following on the law? Excuse me, following the law and reaching a guilty verdict if we prove the elements of the crime charged?
We'll talk to the young lady. I think we need to speak privately. Thank you. It's Ms. Gibbs.
Take a moment to confirm.
Sure.
I just want to make sure I talk to everybody, at least once before I sit down. Mr. Gant, would you like to focus on the facts and follow the law? Would you let personal feelings or opinions get in the way of measuring the evidence, weighing the evidence? Okay. Mr. Romero, would you be able to focus on the facts and follow the law? Not let personal opinions or feelings get in the way of reaching the verdict that the evidence suggests? And Ms. Klein? Would you be able to focus on the facts and follow the law?
Yes.
Mr. Gonzalez, do you think any personal feelings or opinions would get in the way of you finding the verdict that the evidence supports?
No.
Thank you for your attention, everybody.
All right, thank you, ladies and gentlemen. So this is what we're going to do. I want to give you a little stretch break and comfort break, and also if you wanted to get a little snack or something. I know you've been here for a number of hours already, but I'd like to have the defense also speak with you before you actually, we actually break for lunch. I'm looking to see, okay, there's a few people that we do need to speak with privately. Robert, what we're gonna do is, I want to speak with the lawyers for a minute to determine when we're gonna take a lunch break. Because I don't want the jurors to have to also wait until 1 o'clock or 1:30 to have lunch. So we may even wind up doing it now. But there's a few that I want to speak with privately. And Miss Rodriguez Carrillo is going to wait outside right by the door, number 2. Mr. Lubin, number 25, also right outside the door. And Miss Gibbs, number 29. I want to speak with them privately for a minute. But I'm going to give the other jurors just about 10 minutes now to stretch, use the restroom, and then we'll let everyone know if we're going to take the lunch break then, okay? What? Just hold on. All right, if you would do that? All right, thank you.
Following up?
All right, everyone, please be seated. Thank you. All right, ladies and gentlemen, I believe the defense would probably take at least, 45 minutes in their voir dire. And then we have to discuss all of you and select a jury. I don't want to keep you from having the lunch that late. That's way too late. So I'm going to send you now to lunch, and that's why I had to bring you all back in, because I have to give you some instructions. There's 2 restaurants in the building. You can leave the building if you like. The lunch hour is going to be 1 hour. I'm going to have you back here at 1:25. Okay. Please do not discuss anything we've talked to you about. Okay, with each other. Don't discuss it. Don't discuss anything we've explained, any of the discussions that council has had with you, anything anyone has said during the jury selection so far. Also, don't do any research to try to gather information, because then you're going to taint this whole panel. That's not evidence. You haven't received any evidence. You've gotten a few names, you've gotten what the allegations are. Don't try to do research or investigate or go on the internet to gather information, because you're going to taint the whole process. I'm going to have to strike the whole panel. Okay. If you see any of us during the lunch break, we're going to ignore you. We're going to continue to ignore you. Don't take it personally. We're not going to talk to you. We're not going to get in an elevator with you. We're not going to say hello. It's nothing personal. We're all invested in maintaining the integrity of the proceedings. Even a pleasant hello can be misinterpreted. If you have anything you need to say or any problem or question, go to Robert. Robert will take that information from you and bring it to my attention. We'll see what we can do to resolve whatever the issue might be. Okay. So Robert, where will they meet you? You're going to tell them outside where they'll meet you after lunch?
Yes,
All right. So at 1:25, it's a little over an hour. Robert's going to let you know where to meet him. Don't come into the courtroom though. Okay. And the instructions I'm giving, please, everyone here, no contact or communication with any of the jurors. Right? Okay. And after lunch again, we'll finish up with the voir dire from the defense. Then we'll select a jury and have you on your way. All right. Thank you very much.
All right, for George.
Okay, we're on the record. I'm going to be bringing the jury back in a moment. We'll continue with the voir dire. Completed. It's really cold in here. I'm so sorry. Thank you. Everyone can be seated. Wonderful. Thank you, ladies and gentlemen. Hope you had a nice lunch. We are, I'm sorry,
Juror number 25 is missing.
juror number 25.
We talked to him.
Oh, Mr. Lubin.
Yeah, he's missing. I don't know why.
Okay.
I'll keep an eye on him.
Yeah, keep an eye out for Mr. Rubin. All right, very well. Thank you, ladies and gentlemen. Again, hope you had a nice lunch, and we are ready to proceed now, the defense with their voir dire, with their questioning of you. Thank you, counsel.
Yes, sir, thank you.
Mhm.
Good afternoon, everybody. How's everybody doing after lunch? Good. I got some headphones, lots of energy. Promise to be as efficient as possible. Hopefully get you out of here for your 2:30 cafecito. I think everybody's, due for that, right? I see some heads nodding. Okay, great. All right, so earlier today, you had a very important conversation with the state, and like the state, we also have an opportunity to speak with you. And as the judge mentioned, this is the only time that we're gonna be able to speak with you and really get to know you and get a feel for you. It's really important, that everyone understands. This man right here is facing one of the most important events in his life. And we need to pick the right jury for this case. It's nothing personal. Maybe you can sit for another case if you're not selected. Now, can anyone here, by a show of hands, tell me what this young man's name is? Can anyone, by a show of hands, tell me what this young man's name is? Thank you. I'll be on the jury more long. I see Mr. Jonas, juror number 28, and I see you, let's see here. Ms. Fernandez, juror number 10. Thank you. Can you tell me what his name is?
I didn't hear you, but it's
Close, that's good. Mr. Jonas?
I believe it was pronounced sentences.
Very good, yes. Mr. Jonas is here. It's gonna be called a lot of things. It's gonna be called the defendant, the accused, the suspect. It's very important that everyone remembers that he has a name, Mr. Senadis, and he is very thankful for each and every one of you being here today to help us with one of the most important rights that our Constitution allows us, which is a right to a fair trial. And not just any trial, but a trial with a jury of his peers. Now, I noticed Mr. Rodriguez, juror number 7, you sat for a civil jury, correct? Now, in a civil trial, can you tell me what the dispute is about? I'm sorry?
Can you repeat the question?
Yes, what was the dispute about at the civil trial? Yes, you were on a jury for a civil trial,
Yeah,
right?
but I wasn't sure for that, right?
You weren't selected?
Yeah. I was-
Okay, well, can anybody else tell me at a civil trial what the dispute is usually about? Yes, your name, I'm sorry, sir?
Number 36.
Number 36, we have Mr. Perez, Santiago Perez. Can you tell me what the dispute is usually about?
So usually it's not the state, it's one party, usually one party is from breaking something or doing something like that.
Right, and usually it's the parties arguing about money, right? Here, it's a little bit different, and it's very important to remember that. We're here today in the criminal court. Now, as the judge mentioned earlier, Mr. Senegas has the right of being presumed innocent before his verdict, before any evidence is heard, he is innocent. Does everyone here agree with that?
Yes.
Yes, I see lots of heads nodding, I heard a yes, okay. Now, the burden of proof, as a judge instructed and will instruct you later today, this table right here has the duty to prove to you every single element in this case beyond and to the exclusion of every reasonable doubt, okay? Now, that means that the defense, well, I can assure you, we're not gonna play tic-tac-toe, we're not gonna do crossword puzzles. We don't have a duty to bring forth a single piece of evidence. Does anyone here feel the need to hear from the defense before rendering a verdict? I see Mr. Piloto said no. That's juror number 13. Anybody else? Does anybody feel the need to hear from the defense before rendering a verdict? Well, let me see. Juror number 33, Mr. Cruz Lago, I see you putting your hand up to your ear. Can you hear me okay?
That's hard for you to hear most.
Okay, no worries. Would you would like me to ask the judge to see if you can move?
My hands up here are fine.
Okay, perfect.
Okay.
So in that same vein, under the presumption of innocence, we also have the right to remain silent. Does anyone here feel that Mr. Senegas must take that stand today and testify for his innocence? Or just prove his innocence? Does anybody need to hear that? I'm seeing nods, no, okay, no hands. All right, so Mr. Piloto, juror number 13. Earlier today, the state spoke to you about your children. You have small children, right?
Sure.
2, even better. So now we have 2 children, cookies all over their face, right? Nowadays, parents have cameras at home, right? Regardless of whatever story your children told you, if you had cameras in the home, you would just go back and check it, right?
Sustain. Sustain.
Okay. Now, along that same path with the cookies, the judge also talked about a recipe. Now, who here has cooked a cake or any type of recipe that has measurements? I see a hand over here, 2 hands, 3 hands. Okay, Ms. Fernandez, juror number 17. Would you agree with me that sometimes recipes have like 1.5 cups of sugar, not just 1 whole cup of sugar, right? Now, if you put 1.5 cups of salt, or you only put 1 cup of sugar, it's not the same, right? Okay, so even though the state here mentioned today that your job is simple, 1 + 1 = 2. 1 + 1.5 does not equal 2. So if the state fails to prove even 1 element, a part of an element, if you have a reasonable doubt, you must do the same thing with the case that you do with that cake. You throw it in the trash. It's a not guilty. Does everybody here agree with me? I see nods, okay, I see Mr. Moncrief, you're nodding, that's juror number 43. Mr. Moncrief, you mentioned a few things in your juror questionnaire regarding your son. Would you rather speak to me in private about it? You're okay with speaking in public? Okay, great. Your son was shot twice. That involved obviously a firearm, right? Would that weigh on your mind knowing that this case also involves a firearm.
It's a little bit tricky, I would say, because there wasn't someone specific that they pointed out that he did it. It was like,
Okay.
but it's a whole lot more than that, so for me, it's just a little bit tricky.
Okay.
So I'm sorry, I didn't mean to interrupt. I want to be clear. So are you saying that you would be able to separate out the circumstances if you were chosen as a juror in this case and focus only on the evidence you hear in this case?
It's not like this, Your Honor.
Okay,
But it goes with the evidence what is, I said, produced or. Yeah, this one, what is produced, what sort of evidence is produced.
okay. So you'll able to wait and hear what the evidence is and and you won't come to any conclusion until after you have heard all the evidence. Okay, all right.
And Mr. Moncrief, not to keep picking on you, but just, I want to make sure, because you mentioned that in your son's case, there was no specific defendant, correct? There's nobody that you could point a finger to as a random drive-by. In this case, Mr. Mendez is being accused. The finger is pointed at him. Would that weigh on your mind when you're rendering a verdict in this case against him?
Really, I would think a little bit about it. Something with your, a little bit issue. Honestly.
Okay, no, today's about honesty, everybody.
Something with your, this issue for me. Honestly.
I appreciate your honesty. Thank you for that. Does anybody here agree with Mr. Moncrief? Just hearing about a gun in this case, hearing that the accusation involves a gun, would anybody be immediately offended or have like a gut reaction and just don't like the fact that a gun is involved?
To the point where it would affect your ability to sit and listen to the evidence and judge this matter only based on the evidence, not based on your feelings. Because again, your decision cannot be based on emotions and feelings. That cannot play a part in making your decision here. It would not result in a fair decision. Okay? So anyone have that concern? All right, we already spoke to the gentleman.
Yes, juror number 25. Anybody else? I believe I saw one more hand over here.
There's a young lady here.
Okay, I have, this is Ms. Figueroa, juror number 25. Okay, thank you so
Juror
much for your
number-
honesty.
Juror number,
Number 5.
Ms. Figueroa is juror number 5, correct? Okay.
All right. Now, the law in Florida states that as long as you have a valid concealed weapons permit, you can carry a gun on your person concealed. Does anybody here have an issue with that law? Does anybody here disagree with that law? I see nods, no. This is our juror number 9, Mr. Salvo.
I know.
I'm sorry, sir. One more time.
Oh, me?
Yeah,
I grew up without guns in my family.
right.
I know the COVID's gun failures. I know who protect guns. Yeah, I mean, I don't see the use, but it, doesn't pertain to this person's,
Well, here's the issue I think council's raising. The law allows it,
yeah.
and that's the law. And again, you've raised that, you don't like it. You're not comfortable with it. You don't see the need for it. The question again is, if you're on this jury, can you and will you follow the law?
Presents evidence to all those elements. Yeah.
Okay,
But, I can't deny that.
you're how you feel about something. Right, and that's why we want to have the conversation, because we want to make sure you can say to us, your feelings will not interfere with your objective evaluation of, you haven't heard anything yet, but whatever it is, It can't. And if you believe it will, you need to tell us that. If you believe it won't, then you're okay. Either way, you're okay, actually.
I also see juror number 15, Mr. Crandell, can you?
Yes.
Please share with
It's kind of goes back to what I was saying before the break, that law, the concealed carry and all that, it's something that I go back and forth all the time. I hear arguments for it, I hear arguments against it, and the mind changes a lot. And it's also, like I said before, I want to say that, I could definitely follow up, I see the 4 elements, I would put guilty, if not guilty, but I can't say I'll know until I'm in the position. I don't want to say definitively I can.
Well, and again, you have to go back to, yourself, and you put yourself in a position where either in your job or in your schoolwork or whatever it is, the tasks that you perform, and yourself, are you going to base your function, or do you base your function on emotions and feelings? Because that can't be the case here. Okay, so again, and that's the question. Only you can answer that, because we don't know you.
No, I understand. Honestly, I wish I could answer it definitively also, but I guess until I'm in the position, so if I'm selected. And I hear the-
Well, you've never been on a jury before,
Right, exactly. So-
but you've performed other tasks in your life of significance, and I think that that's probably the best way to figure out how you respond to circumstance, how you respond to this is the task, and just by nature of how you do it anyway, making those decisions that you have to make.
I would certainly try my absolute best to
Sure.
follow the procedure, definitely follow what my duty as a juror would be, and act as impartial as I can. It's biased in one way or another, because I find changes a lot quicker than.
Let me ask you this. Do you recognize anyone in the room? Do you recognize counsel, by the way, the one speaking? No? Okay.
In that vein, should I
You can
continue?
follow up.
Mr. Crandell, are you related in any way to Robert Travis Crandell?
Yes,
Who is he to you?
he's my dad.
Okay, and just for full candor of the court, to place on the record, I was a neighbor to your father for many, many years. I know him. I don't believe I've ever seen you. I don't think we've crossed paths. Do you recognize him? No? Okay.
Let me ask you this, Mr. I'm sorry to keep picking. I hope you don't feel we're picking on you, but it's good because you really broke the ice and you're participating. Do you live independent, or you live on your own? You live with family?
I
Where?
live with family right now, I'm independent with my mom and with my mom.
Okay.
I lived up in Orlando where I went to college.
Oh,
The
okay.
last 2 years before I came down to the pandemic.
Okay.
But before that, before I went to college, I lived with my mom the whole way.
Okay. So now you're back here for summer?
I'm back here for a
For-
while.
for a while?
Yes, because I'm about to graduate, and I won't be going back up for a good chunk of it.
Okay. All right. But now currently you're living with whom?
My mom.
You live with your mom? Okay, very good. All right, counsel, go ahead.
And just to reiterate, does your mom live in Miami-Dade County?
Yes.
Another very important part of this case is going to involve a car accident. Now, car accidents can be very serious. They can involve injuries. Has anybody here, has your life been significantly impacted by a car accident? I see the skips in the back, juror number 29, I see juror number 28. I have, is this Ms. Franco, juror number 1? Ms. Franco, are you comfortable speaking about that?
I lost my cousin in the car.
Sorry to hear that. I'm sorry to hear that.
That is, something heavy, something deep. Understanding that a car accident is involved in this case, would you be able to objectively render a verdict in this case without holding any type of thoughts or emotions that would affect your verdict?
It's a hard one.
I'm sorry.
I said it's a hard one.
Mhm.
I think about, they don't even think about it going off. It's my first cousin.
Thank you for your honesty, I appreciate that. So we also have Juror number 28, Mr. Jones, can you please explain to me, are you comfortable speaking in public? Would that car accident weigh on your mind in any way? Would it affect your verdict if you were chosen for this case?
It would not, it only affects me when I drive at night.
Okay. I also saw Ms. Gibbs in the back, juror number 29. Would that car accident that affected your life, would it affect your verdict in this case if you were selected? Did I miss anybody else? Anybody else affected by a car accident? Okay, so Mr. Hodge, I believe?
Yes.
Juror number 40. Knowing that, you had this car accident affect your life, would that weigh on your mind when rendering a verdict in this case?
A little bit, but just 6 months ago, so.
Okay,
Just that.
I see. I'm sorry to hear that. Do you think that you would be able to be fair and impartial towards Mr. Sinatus with that in mind? I'm sorry, can you
I
repeat
don't
that?
think it would affect me.
Okay, and not to pick on you too much either, but while I have you here, I saw in your juror questionnaire that you were a former police officer.
Yes,
How long ago since you retired?
10 years ago.
Thank you for your service.
What department did you work in, sir?
Metro Dade.
Now, how long were you a police officer for?
I'm sorry.
How long were you an officer for?
28 years.
Okay, so with 28 years of experience, you must have been involved in many different scenarios and investigations, right?
Yeah.
Now, would your experience or bias, whatever your thoughts might be towards, how investigations should be conducted, or what would be considered a complete investigation, would that weigh on your mind at all when rendering a verdict in this case?
Let me ask you this, let me ask you this, are you going to allow your background and whatever experiences you have had in law enforcement affect your ability to sit and listen to the evidence objectively and make a decision based on the evidence and the law?
I want to say, I don't think it will. It's 20 years.
It's many years in that work.
Yeah.
Okay,
I don't.
all right, fair enough.
So, juror number 36, Mr. Perez. You mentioned some things in your juror questionnaire that I'd like to explore regarding your family and a crime. Are you comfortable speaking in front of everyone, or would you rather speak in private?
No.
Okay, thank you. Now, you mentioned that your family had been carjacked at gunpoint. You mentioned that your family had been carjacked at gunpoint, and I'm very sorry to hear that that happened to them. I would ask, since that case involved a gun, and this case involves a gun, would you be able to be fair and impartial when judging Mr. Sinatus in your verdict, or would that affect you?
It would not at all.
Juror number 44, Mr. Gonzalez. How you doing? Can you hear me back there? Okay, perfect. You mentioned something about your mom in your juror questionnaire. Are you comfortable speaking in public?
Sure.
Okay, so this is another, and it's just not just for Mr. Gonzalez, this is for everyone here. Obviously, Mr. Sinatus is a person of color. He's a member of our community, a minority. Mr. Gonzalez, based on what you mentioned on your juror questionnaire, do you have any type of feeling or bias towards a person of color or a person who's an immigrant to this country?
No, that was just a quote from my mother.
Understood.
Add something else to the answer.
I'm sorry. I didn't hear that.
I'm adding something else to that comment that we don't say.
Okay.
Okay. Mr. Cruz Lugo, you're number 33. What do you do for work?
Me?
Yes.
I'm a PR man.
A PR representative?
Yeah.
Okay. And in your job, you must talk to a lot of people, right? Lots of people from different backgrounds, different cultures,
Sure.
and you have to be able to make business with them, right? And be successful, right? Okay. So in this case, we're also gonna have people from different backgrounds, different positions in life. We're gonna have civilian witnesses, we're gonna have police officers. In your mind, would you ever give a police officer's testimony more credit than a civilian's testimony?
Well, I guess it depends on the police officer. doesn't it?
I mean, what are your thoughts?
I mean, no, generally no. But if a police officer is, particular, has a outstanding reputation, right?
All right, well, let me-
Police officer has-
I'm gonna interrupt you right there, because I want to talk about the law. Okay? You're gonna get an instruction on the law. Police officers, law enforcement, like any other witness, is human. That's not the instruction, but, and they're to be treated like any other witness in assessing their credibility. In other words, a witness walks in, whether they walk in as a police officer or as a civilian, the way you assess their credibility, you use the same criteria, the same factors. Police officers are not more credible or less credible than any other witness. You determine, as they are human, like other civilian witnesses, you determine whether or not they have a good memory, they've made a statement that is inconsistent with something they previously said, whether they have an interest in the outcome of the case, their perception, if any, of the events. You're going to get a whole instruction on that, what the law is, but the same tools you use in assessing credibility of any witness, you use similarly with regard to police officers. Did you have a question, sir?
Yes.
This is Mr.
Mr. Jones, number 28.
Mr. Donis. Yes, sir.
Will we be privy to any training that they may have had? As police officer?
Well, as part of qualifications, but that, again, when you assess a credibility of a police officer witness, they are not experts in anything. They are not certified. We don't have them testifying as expert witnesses. Expert witnesses is a whole different way to evaluate the testimony, and you're given a legal instruction on that. Police officer witnesses are assessed the same way as civilian witnesses, as any other person testifying. Okay?
Yes.
So there's no confusion. My answer is that the answer is no. I will not place any special.
Because you started to say about, reputation and things, and that's why I stopped you, because again, whatever you hear from the witness, I should read you the instruction actually, but the law will explain to you and remind you how you need to evaluate their testimony.
I should say that I misspoke, and what I meant to say was that it would have to do with the presentation and the demeanor of the police officer.
Excellent point. You make a fabulous point, because that's one of the things that you look to determine credibility of any witness. How are they acting? Their presentation, eye contact. There's many things that you'll look to determine if you find the information reliable. Someone could be untruthful, mistaken. There's a variety of things that you look at. So you make an excellent point about their demeanor. Absolutely. Go ahead. Yeah, I'm sorry. Yeah.
Okay, so does everyone agree civilians and officers are should be assessed equally? And nobody should be on a higher sentence than anybody else. Does everyone agree? I see heads nods. Yes, Ms. Valderrama, juror number 11, do you agree with that? Okay, does anybody here disagree with that? Does anybody here believe that because an officer took an oath, his testimony should be weighed at a higher level of credibility than a civilian?
And, you know, sometimes also, someone may have had a very favorable experience with someone in law enforcement, or maybe a negative experience. Again, those personal experiences, you have to put them aside. Okay, and judge the individual based on what they present to you in the courtroom, and not based upon those experiences. Someone may have a close relationship with someone in law enforcement. You may have, again, very favorable feelings or negative feelings. But every law enforcement officer must be treated as a witness the same you would any other witness. Does anyone have a concern that they will, because of an experience or relationship, will be unable to judge a law enforcement witness in the same way as any other witness?
I see no hands.
Not seeing any hands for the record. Thank you.
Okay, now, Ms. Cabrera, what do you do for work? This is juror number 12. You're a waitress, okay. What about juror number 23, Ms. Cabrejas, what do you do for work?
I'm sorry?
You do echocardiograms? Okay,
So you're a tech? Mhm.
okay, now let's talk a little bit about civilian witnesses. You can also put police officers into this. Can anybody give me a reason why somebody might lie on the stand? I see a hand, citizens. My friend in the back over here, what's your name? Okay, Ms. Klein, can you tell me why somebody might lie on the stand? For personal statements. Okay,
They may have an interest or motive to, for their own benefit. Good point.
any other reasons? I think we have a hand over here. Mr. Thank you, Santiago, Mr. Santiago Perez. Can you tell me why? Okay. I had another hand over here. Yes,
And who is that? Okay.
Ms. Lago.
Mm-hmm.
Can you tell me? It's a great point. So, like the judge said, and like you've heard today, it's gonna be your job, whoever's selected for this jury, to give weight and credibility to the testimony that you hear today. The conflict in the testimony, the demeanor on the stand. If their answer wavers and vacillates, when defense counsel gets up and asks questions, but when the state gets up there, their answers are very direct. You have to take all these things into consideration. And you're the only ones that can place the weight. If you find that it doesn't weigh anything, it's gonna be your job to discredit that testimony, not anybody else here. Does everyone here agree with that? I see hands, okay, nodding, yes, Mr. Pinotto, okay.
And when you're saying you agree with it, does anyone say, look, I don't agree, but I can do that job? Anyone here have a problem with that? Because you may agree or disagree, again, with what counsel is explaining to you. But if you have a concern or you don't agree with what you're hearing about here, the rules of the house, again, what you have to do the job, we need to know, even if you disagree, are you able to still do the job? Okay, I want to read something to you about weighing the evidence. You're going to get an instruction. I'm not going to read the whole instruction. I just want you to have an idea a little bit more about what you'll hear at the end of the case on the law. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? So those are, there's more, but those are the examples of how you weigh the evidence. Okay, counsel? Mhm.
Now, just on a final point to that, our juror number 36, Mr. Perez, we mentioned earlier that your family was a victim of a crime. Would you be inclined to give more credibility to a witness that is alleged to have been a victim of a crime here in this case? Okay, does everyone here agree with Mr. Perez? Yes, Mr. Ivanez, you're shaking your head yes. Okay, that's juror number 32 for the record.
Let me ask, does anyone here, if you've been, or someone close to you, ever been, and we asked this question actually in the general questions, ever been the victim of a crime? Is that, okay, there's a couple hands. Is that situation or that circumstance going to impact you in any way in objectively listening to the evidence presented in this case and making a decision only based on the evidence and the law? All right, the gentleman there, we spoke with Mr. Lubin. Because, as I said many times already, sympathy, emotion, bias cannot be a part of your decision-making process, because then your decision's not fair. Then it's tainted. So it seems strange, but we need to know this before you're selected, because it's too late after. Then you're on the jury. Okay? That was the young lady that we had spoken before about that. Very well. That's juror number 1, young lady here, Ms. Franco, that she mentioned. Thank you for reminding me. Yes, thank you. And the young lady in the back.
Yeah, my biological mother I can't really say if it would like.
Okay, so that's something that, you know, has happened. You don't, can you say if you can, you know, put that out of your mind and not hold anyone responsible here for that? Okay.
That's something I've lived in my entire life, so.
Sure.
It comes up, but it's not really anything that is like, oh, hey, well, I'm gonna go do this now because that happened.
Right. So you feel you'd be able to make a decision despite the tragedy
Yeah.
that has occurred, you'll be able to make a decision based on what you hear in this case and that alone. Okay, very well. Thank you, madam. And that is Miss, yes. Mm-hmm.
So in closing, at the end of this trial, you've heard all the evidence, you've heard all the testimony, you've seen everything the state has to bring forward, and you still have a reasonable doubt. Ms. Ramos, juror number 6, what is your verdict? I'm sorry, can you hear me? Not guilty? Okay, does everyone here agree with Ms. Ramos? As the head's shaking yes, okay. Now, if at the end of the trial, you have more questions than you have answers, you look to this table and what verdict are you supposed to render? Ms. Fernandez, juror number 10. Yeah,
You have questions?
yes, and you have no answers for those questions. And they're reasonable questions, reasonable doubts. Okay, and if something is not clear, and you think maybe Mr. Sinatus is guilty, maybe. Ms. Fernandez, juror number 24, what is your verdict?
Is maybe enough?
Well, the thing is, like, are you talking about a clarification that I might want, or there's like?
No, let's say you've heard all the evidence, the argument of the lawyers, the law, and you're back in the jury room because the verdict is a unanimous verdict, but it also needs to be the verdict of each person individually. You're entitled to your own decision. And you have a question at the end and you think, well, I'm pretty sure maybe Mr. Sinatus is guilty. Is that sufficient beyond every reasonable doubt? Okay.
So what would your verdict be? Okay,
Does anyone disagree with that? That maybe, that's pretty good. Is that enough?
juror number 22, and please don't touch me for this. Ms. Dixworth, did I get that right?
Me-
Yes? Okay.
Mhm.
Do you agree with that? Your verdict would be not guilty? Okay, Mr. Gant, haven't spoken to you today. How you doing? Good. All right, so how old are you? You're 19. Is this your first time in front of the jury panel? All right, so let's say you're in a room, you have all the other jurors. And the other jurors, everyone's young in my eyes, but let's say they're a little bit older than you, okay? And your reasoning, your questions, your doubts, and your verdict doesn't match what everybody else in the room is saying. Would you feel comfortable enough to stand up for yourself and stick to your guns and say, this is my verdict? Yes, and would you be comfortable giving a verdict that is different to everybody else in the room? Mr. Grindel, do you feel the same way? Would you be able to stand up for yourself and stick to what you believe in and say if your verdict, even if your verdict was guilty and everybody else was not guilty, would you be able to stand up for yourself?
Yeah, after hearing all the evidence and coming to myself, I think I will.
Okay. Juror number 27, Ms. Chanelli, what do you do for work?
I work at a warehouse, like quality control.
Okay. Mr. Romero, what do you do for work? Juror number 26?
I work for the EMT for,
I'm so sorry?
EMT and that for hackers.
Oh, okay, so like a paramedic?
EMT.
EMT, okay, so I'm an emergency medical. Got it. Judge, may I confirm with proposal?
Sure.
Mr. Rodriguez, juror number 7. You've heard all the evidence in this case. Okay, we're at the end of the trial. We're getting ready to wrap up, and you have a reasonable doubt. You have one, you're thinking about it, you think it's possible that Mr. Sinatus is guilty. You might even think it's probable, but you still have a reasonable doubt. What would your verdict be? Not guilty? Okay. Ms. Ramos, juror number 6, do you agree?
Yes.
Even if it's probable, but you still have a reasonable doubt, your verdict would be not guilty?
Yes.
Mr. Ibanez, what do you do for work?
I'm sorry, which juror number are you?
Juror number
32.
All right, thank you, sir.
And do you agree as well? Even if you thought it was probable, but you had a reasonable doubt, would you still render a verdict of not guilty?
Yes, I will.
Juror number 16, Mr. Velazquez. You mentioned that your wife was a judge in Colombia, right? Do you know what kind of law she practiced or what kind of cases she heard? Okay, so with that in mind, and then let me see if I gather everything. You said in this country here, the way we practice criminal law, you begin presumed innocent, not guilty. And it is the state's job to prove the guilt, correct?
Yes.
However, in your country, Colombia, you begin in the opposite way, correct? Where you have to prove your innocence. With that in mind and understanding that difference, would you be able to follow the law here today and presume Mr. Seneda's not guilty before hearing all the evidence? Ms. Berwick, juror number 39, how are you? Good, thank you. So what do you do for work?
I'm a journalist,
And who are you a journalist for?
the current one I'm working for the Department of Health. Investigator.
Okay. And taking your work in mind, you know, you have to, you're a journalist, so you have to give a non-biased approach in your writings, correct? And with that in mind, would you, with that same frame of mind, would you be able to judge today in Mr. Seneda's case and presume him not guilty before hearing all the evidence?
Of course, we use the line of the law.
Okay, does everyone else agree with that sentiment that we have to follow what the law says? I see head nods, yes, okay.
Okay, counsel, start the question.
Ms. Ortiz, can you tell me, juror number 38, can you please tell me what you do for work?
I'm a registered nurse.
Mr. Lopez, juror number 48, can you please tell me what you do for work?
What else, man?
Ms. Alfonso, juror number 47, what do you do for work? Okay, what are you gonna be doing? Consulting? Congratulations on the graduation. What did you graduate in? Where did you graduate from? I'm sorry, you said Boston University? Yeah, it's a great school. Mr. Ramirez, juror number 37. Can you tell me what you do for work, please?
Renovations and home repair.
Okay. And Ms. Fernandez, juror number 10, can you tell me what you do for work?
I'm a general revenue agent with the IRS.
And does your work involve any type of investigations?
No, I do audits, but not investigation. I don't work for CPS.
And this is Diana Fernandez.
Yes.
Counsel?
Just one second. All right, thank you so much, everyone, for your time. I appreciate you all staying with me. And like I said, This is the only time that we're gonna get to speak with each other, so please don't hold it against me. If I don't speak to you in the hallways because I can't, I'm not allowed to, not because I don't want to. And thank you, Judge.
All right, thank you. All right, ladies and gentlemen, you're going to give us about 15, 20 minutes now, maybe a little longer. Please be patient. We're going to discuss all of you and we're going to select a jury. Do not discuss this case with each other, with anyone else. You're going to take a break now. I'm going to ask you to please check in with Robert by 2:45. Check in with Robert by 2:45, and hopefully we'll be able to bring you back into the courtroom. All right? Thank you very much.
Thank you.
Reason. Chris, let me give this back to you. I'll make a copy of it later. I don't need it now. No, I'll make a copy later. Okay, then that's great. Perfect, thanks. All right, thank you, everyone. Please be seated. Welcome back to the icebox. Whew. That's cold. You've been a wonderful group. Thank you so much, everyone, for spending your day with us. I hope that this was a worthwhile experience for you, understanding a little bit how we operate. And we're so grateful that you as citizens in this community, despite the inconveniences and the disruption in your lives, you come to serve on the jury when called to duty. So thank you again, ladies and gentlemen, for your time and your patience as you worked with us today in the icebox. But you've really been terrific. Thank you again. The following individuals, I do need you to stay for a few moments. You've been selected to serve as the jury. I have to have you sworn in and give you some instructions for tomorrow. Okay? So if you hear your name and your juror number, please remain in your seats. If you don't hear your name and juror number, that means you've completed your jury service. We thank you again. You're going to be excused and you'll be able to, I think, go online and get the information you need so you have proof of your service here as a juror. All right. Please remain if you hear your name and number. Juror number 23, Jacqueline Cabrejas. Juror number 12, Isabel Cabrera. Juror number 26, Brian Romero. Juror number 6, Alicia Ramos Perez. Juror number 17, Maciel Fernandez. Juror number 20, Gabriela Perez Lago. Juror number 13, Miguel Piloto Villamonte. And juror number 27, Rebecca Chinella. Am I good, Chris?
Yes, ma'am.
Excellent. All right, everyone else is excused. Thank you.
Everybody that has a call, come this way, follow me.
Are you going to say?
Oh, sorry.
All right, you can all be seated. Thank you. All right, ladies and gentlemen, we're going to have you sworn in now. Chris?
Please stand and raise your right hand. Do you solemnly swear or affirm you will well and truly try the issue between the state of Florida and the defendant and render a true verdict according to the law and the evidence? Please say I do. Thank you. Make a seat.
Very well. All right, ladies and gentlemen. Ladies and gentlemen. Let me tell you a little bit about what to expect the next day. And we may be able to conclude the proceedings tomorrow. If not, we'll conclude them certainly by Thursday. I'm going to ask you to be here tomorrow morning, no later than 8:45. And it was a little bit of a delay this morning because we're just kind of working into new procedures. Should be a lot easier for you tomorrow. When you arrive tomorrow, Robert will give you a place where to meet him in the courthouse. He may ask you just to wait downstairs in the reception area, but I think he'll find another place for you to wait. And when we're ready to bring you into the courtroom, we're going to be in my courtroom, which is courtroom 4-6. Okay, but don't go to the courtroom. Go to wherever Robert, when they come in tomorrow, no later than 8:45, Robert, I said that you'll tell them outside where to meet you.
I'll get with it right now. Let them-
All right, it's a big secret, just between all of you. We don't want to know. Okay. You can bring a lunch if you like. You can bring snack if you like. We can keep your lunch for you. Bring a sweater or a jacket, maybe a hat and gloves. I think my courtroom is cold also, maybe not as cold, but pretty cold. We want you to be comfortable. You'll have your juror parking again taken care of. Please don't do any research or investigation. Don't try to gather information, because then you're going to taint the whole case. You're going to taint the panel. You're going to taint yourself, and we're going to have to start again. Everything will then be a big waste of time. Avoid the temptation to be curious. You have no information. You have no evidence. Okay, so please, again, do not try to gather information, because that's not evidence. You only get it from the courtroom, and that's all you can rely on in ultimately reaching your verdict. If you see any of us outside of the courtroom, we're going to continue to ignore you. Please don't hold it against anyone. It's not personal. We can't answer any questions. We can't even say hello. If you have a question or any concern or any issue, you see Robert privately, let him know what the issue is, and we'll do our best to try to accommodate and work out the issue for you. Okay? Let's see. Yeah, no research, no investigation. I think I pretty much covered everything. And tomorrow, again, we expect to start at 9 o'clock. Please be on time. I know you were all today. And do not come to the courtroom. Robert, again, will give you the place where to meet him there. And then when we're ready for you, we'll bring you into the courtroom. Okay? And at the end of your service is when you get your certification that you have served. So if anyone has any concerns, sometimes, you know, employers might need a verification. You'll have my information. They're more than welcome to call, and I will make sure they have verification that you are doing your duty here and serving on the jury. Okay. All right, very well. Hope you all have a very pleasant and restful evening. We'll see you tomorrow morning, no later than 8:45. Thank you.
All right. All right.
All right, you can all have a seat.